All right, welcome to the Explainer. Today we're going to break down a really powerful framework for taking control when you find yourself up against a debt buyer in arbitration. And get this isn't about defending yourself, it's about dismantling their case before it even gets off the ground.
Okay, let's just pause on this for a second because this one idea, it's the key to the whole thing. Our first instinct, right, is to jump in and say, no, that's not right. Here's what really happened. But that's exactly what they want you to do. It's a trap. The strategy we're exploring today, well, it flips that entire idea completely on its head.
So think about it this way. What if the whole process is designed to make you talk, to get you to admit to even the smallest detail? Your real power doesn't come from anything you say. It comes from making them prove every single claim. To really understand how to win this game, you've got to understand the weaknesses in their business model first. They run on volume and automation, and believe it or not, that's their biggest vulnerability. You see, their entire system is built on one huge assumption, that you won't fight back. They buy these debts for literally pennies on the dollar, a lot of times with nothing more than a giant spreadsheet. Their whole model relies on your silence. But the moment you start to apply pressure, the second you demand they actually follow the rules, their whole house of cards starts to collapse. So this brings us to a huge fundamental shift in your thinking. This isn't just about changing your tactics, it's about changing your entire role in the process. You're not the defendant anymore. You're the auditor of their case. And this right here, this shows you exactly what I'm talking about. The old way is, I need to prove I don't owe this. The new way is, no, they need to prove everything and I'm going to test all of it. You see how that just completely flips the power dynamic? You go from defense to offense. You're putting their case on trial. And the legal principle that makes this whole thing work is called the burden of proof. It's simple. It is 100% on them, not you. Since they're the one making the claim, they have to provide valid evidence for every single part of their case. Your job is just to test if they actually can. So we've got the mindset. Now let's see how this turns into your first, and you could argue, your most powerful tactical move. This is where the theory gets real. And here's the thing. A lot of times, the battle can be won before you even step into a live hearing. This is all about crippling their case from the very beginning by attacking the one thing it's built on, their documents. And this is the weapon, the motion to exclude evidence. It sounds a little fancy, but all it is a formal request to the arbitrator to just throw out their documents because they don't meet basic legal standards. It's a direct challenge to the very proof they're planning to use. And what's really important to get here is that you're not arguing about the debt itself. You're arguing that their proof is legally no good. You're saying things like, you can't prove these documents are authentic, or this is just hearsay, it's secondhand information, or you can't even prove a clear chain of ownership for my account. And the impact of this? Well, it can be a total knockout blow. If the arbitrator agrees with even part of your motion, the debt buyer is left standing there with a spreadsheet full of numbers, but zero legally recognized evidence. And data by itself is not enough to win a case. Okay, so let's say your motion didn't end it completely, and you're actually heading to the hearing. Now what? Well, you've got a plan for that too. This is your script for applying constant, methodical pressure and exposing every weakness live. It is so important to understand this. Every time you object, you are not being rude. You're not interrupting. You are forcing the arbitrator to stop and look at a specific flaw in their case. You are controlling the flow of information and building a record that shows their evidence is weak. These are your tools. So when their witness tries to talk about records they didn't personally create, you object lack of personal knowledge. When they're relying on secondhand info, you object hearsay. Every single objection just chips away at their credibility, showing the arbitrator that their case is really built on assumptions, not facts. Now, when it's your turn to question their witness, you follow this exact repeatable process. The whole goal is to get them to admit, step by step, that they have absolutely no firsthand knowledge of the account, the documents, or how the balance was even calculated. And it all leads up to this one power phrase. This question is designed to get a simple yes or no answer that just locks in their witness's lack of knowledge for the record. There's no room for them to waffle. It makes your point crystal clear. And remember, through this whole process, you say as little as you possibly can about your own situation. The spotlight is never, ever on you. It's always on the weaknesses and the failures of their case. So when it's time to wrap up, you conclude by just connecting the dots for the arbitrator.
You summarize how the claimant brought a case, but they fail to prove they owned it, they fail to prove the amount, and they fail to bring a competent witness. Bottom line, they did not meet their legal burden.
So let's bring all this together, because this entire strategy is really powered by one core philosophy, and that is replacing hope with structure.
This isn't about hoping you get a sympathetic arbitrator or just getting lucky. It's about creating your own outcome by running a well-defined, systematic process that's designed to exploit the flaws that are already baked into the debt buyer's model. This is how you completely neutralize their psychological game. They expect you to be intimidated, to be overwhelmed, but instead, you meet them with structure, with objections, with methodical resistance. You totally upend their expectations, and you take control of the room. And this is the one thing we really want you to take away from all this. It's the simple idea that is underneath every motion, every objection, and every single question you ask. So in the end, the final question isn't, do you owe this debt? The only question that matters in arbitration is, can they legally prove it according to the rules of evidence? And if the answer to that is no, they simply cannot win.